United States v. McDonald, 435 U.S. 850-860-1978. The court rejected the defendant's argument that the denial of the motion satisfied the third prong. It explained that, quote, "It is true that the deprivation of the right not to be tried satisfies the Coopers and Librid requirement of being, quote, effectively unreviewable on appeal from a final judgment," end quote, but held that the defendants had not asserted a right against trial in, quote, "the sense relevant for purposes of the exception to the final judgment rule," end quote. Id at 801 Tac 02, quoting Coopers and Librid v. Live Say, 437 U.S. 463-468, 1978, quote, "To come within the collateral order doctrine, the order must conclusively determine the disputed question, resolve an important issue completely separate from the merits of the action, and be effectively unreviewable on appeal from a final judgment," end quote. The reason the defendant's argument failed, the Midland Asphalt Court held, was that it overlooked the, quote, "crucial distinction between a right not to be tried and a right whose remedy requires a dismissal of charges," end quote. 489 U.S. at 801, quotation omitted. Quote, "A right not to be tried in the sense relevant to the collateral order doctrine rests upon an explicit statutory or constitutional guarantee that trial will not occur, as in the double jeopardy clause, ... or the speech or debate clause," end quote. By contrast, Rule 6E2 did not, quote, "give rise to a right not to stand trial," end quote, but instead merely created a right to secret grand jury proceedings, the violation of which could be remedied through the indictment's dismissal. At 802. American Oversight's argument hinges on the court's use of the adjective, quote, "explicit," end quote, a word that appears only once in the Midland Asphalt opinion. The court has repeatedly and recently cautioned against, quote, "reading too much into too little," end quote, reminding us that, quote, "the language of an opinion is not always to be parsed as though we were dealing with language of a statute," end quote. National Park Producers Council v. Ross, 598 U.S. 356.